双语音标领航，注音阅读启蒙，叶兴阳有声读物。
Criminal Sociology by Enrico Ferri, Professor of Criminal Law, Deputy Indiana, the Italian Parliament, etc. Preface. The following pages are a translation of that portion of Professor Ferri's volume on criminal sociology, which is immediately concerned with the practical problems of criminality. The report of the government committee appointed to inquire into the treatment of habitual drunkards. The report of the Committee of Inquiry into the best means of identifying habitual criminals. The revision of the English criminal returns. The reports of committees appointed to inquire into the administration of prisons and the best methods of dealing with habitual offenders, vagrants, beggars, inebriate and juvenile delinquents, are all evidence of the fact that the formidable problem of crime is again pressing its way to the front and demanding re-examination at the hands of the present generation. The real dimensions of the question, as Professor Ferri points out, are partially hidden by the superficial interpretations which are so often placed upon the returns relating to crime. If the population of prisons or penitentiaries should happen to be declining, this is immediately interpreted to mean that crime is on the decrease. And yet, a cursory examination of the facts is sufficient to show that a decrease in the prison population is merely the result of shorter sentences and the substitution of fines or other similar penalties for imprisonment. If the list of offenses for trial before a judge and jury should exhibit any symptoms of diminution, this circumstance is immediately seized upon as a proof that the criminal population is declining, and yet the diminution may merely arise from the fact that large numbers of cases which used to be tried before a jury are now dealt with summarily by a magistrate. In other words, what we witness is a change of judicial procedure, but not necessarily a decrease of crime. Again, when it is pointed out that the number of persons for trial for indictable offences in England and Wales amounted to 53,044 in 1874 to 8 and 56. 472 in 1889 to 93. We are at a loss to see what color these figures give to the statement that there has been a real and substantial decrease of crime. The increase, it is true, may not be keeping pace with the growth of the general population, but, as an eminent judge recently stated from the bench, this is to be accounted for by the fact that the public is every year becoming more lenient and more unwilling to prosecute. But an increase of leniency, however excellent in itself, is not to be confounded with a decrease of crime. In the study of social phenomena, our paramount duty is to look at facts and not appearances. But whether criminality is keeping pace with the growth of population or not, it is a problem of great magnitude all the same, and it will not be solved, as Professor Ferri points out, by a mere resort to punishments of greater rigor and severity. On this matter, he is at one with a Scotch departmental committee appointed to inquire into the best means of dealing with habitual offenders, vagrants, and juveniles. As far as the suppression of vagrancy is concerned, the members of the committee are unanimously of opinion that the severest enactments of the general law are futile, and that the best results have been obtained by the milder provisions of more recent statutes. They also speak of the utter inadequacy of the present system in all the variety of detail which it offers to deter the habitual offender from a course of life, which devolves the cost of his maintenance on the prison and the poorhouse when he is not preying directly on the public. The committee state that they have had testimony from a large number of witnesses supporting the view that long sentences of imprisonment effect no good result, and they arrive at the conclusion that to double the present sentences would not diminish the number of habitual offenders. In this conclusion, they are at one with the views of the Royal Commission on Penal Servitude, which acquiesced in the objection to the penal servitude system on the ground that it not only fails to reform offenders, but in the case of the less hardened criminals, and especially first offenders, produces a deteriorating effect. A similar opinion was recently expressed by the Prisons Committee presided over by Mr. Herbert Gladstone. As soon as punishment reaches a point at which it makes men worse than they were before, it becomes useless as an instrument of reformation or social defense. The proper method of arriving at a more or less satisfactory solution of the criminal problem is to inquire into the causes which are producing the criminal population, and to institute remedies based upon the results of such an inquiry. Professor Ferry's volume has this object in view. The first chapter, on the data of criminal anthropology, is an inquiry into the individual conditions which tend to produce criminal habits of mind and action. The second chapter, on the data of criminal statistics, is an examination of the adverse social conditions which tend to drive certain sections of the population into crime. It is Professor Ferry's contention that the volume of crime will not be materially diminished by codes of criminal law, however skillfully they may be constructed, but by an amelioration of the adverse individual and social conditions of the community as a whole. Crime is a product of these adverse conditions, and the only effective way of grappling with it is to do away as far as possible with the causes from which it springs. Although criminal codes can do comparatively little towards the reduction of crime, they are absolutely essential for the protection of society. Accordingly, the last chapter, on practical reforms, is intended to show how criminal law and prison administration may be made more effective for purposes of social defense. W.D.M. Contents. Chapter 1. The Data of Criminal Anthropology. Origin of Criminal Sociology. Origin of Criminal Anthropology. Methods of Criminal Anthropology. Relation between criminal anthropology and criminal sociology. Criminal anthropology studies the organic and mental constitution of the criminal skull and brain. Criminal physiognomy. Physical insensibility among criminals. Criminal heredity. Criminal psychology. Moral insensibility among criminals. The criminal mind. 2. The data of criminal anthropology only applies to the habitual or congenital criminal, the occasional and habitual criminal. Comparison between the criminal and non-criminal skull. Anomalies in the criminal skull. The habitual criminal. The crimes of habitual criminals. The criminal type confined to habitual criminals. The proportion of habitual criminals in the criminal population. Forms of habitual criminality. Forms of occasional criminality. Classification of criminals. Criminal lunatics. Moral insanity. Born criminals. Criminals by acquired habit. Criminal precocity. Nature of juvenile crime. Relapsed criminals. Precocity and relapse among criminals. Criminals of passion. Occasional criminals. Differences between the occasional and the born criminal. Criminal types shade into each other. Numbers of several classes of criminals. Value of a proper classification of criminals. A fourfold classification. Chapter 2. The data of criminal statistics. Value of criminal statistics. The three factors of crime. Anthropological factors. Physical factors. Social factors. Crime a product of complex conditions. Social conditions do not explain crime. Effects of temperature on crime. Crime a result of biological as well as social conditions. The measures to be taken against crime are of two kinds, preventive and eliminative. The fluctuations of crime chiefly produced by social causes. Steadiness of the graver forms of crime. Effect of judicial procedure on criminal statistics. Crimes against the person are high when crimes against property are low. Is crime increasing or decreasing? Official optimism in criminal statistics. Density of population and crime. Conditions on which the fluctuations of crime depend. Quetelet's law of the mechanical regularity of crime. The effect of environment on crime. The effect of punishment on crime. The value of punishment is overestimated. Statistical proofs of this. Biological and sociological proofs. Crime is diminished by prevention, not by repression. Legislators and administrators rely too much on repression, the basis of the belief in punishment. Natural and legal punishment. The discipline of consequences. The uncertainty of legal punishment. Want of foresight among criminals. Penal codes cannot alter invincible tendencies. Force is no remedy. Negative value of punishment. 2. Substitutes for punishment. The elimination of the causes of crime. Economic remedies for crime. Drink and crime. Drunkenness an effect of bad social conditions. Taxation of drink. Laws against drink. Social amelioration a substitute for penal law. Social legislation and crime. Political amelioration as a preventive of crime. Decentralization a preventive. Legal and administrative preventives. Prisoners' aid societies. Education and crime. Popular entertainments and crime. Physical education as a remedy for crime. To diminish crime, its causes must be eliminated. The aim and scope of penal substitutes. Difficulty of applying penal substitutes. Difference between social and police prevention. Limited efficacy of punishment. Summary of conclusions. Chapter 3. Practical reforms. Criminal sociology and penal legislation. Classification of punishments. The reform of criminal procedure. The two principles of judicial procedure. Principles determining the nature of the sentence. Present principles of penal procedure: a reaction against medieval abuses. The presumption of innocence. The verdict of not proven.
The
right of appeal. A second trial. Reparation to the victims of crime. Need for a ministry of justice. Public and private prosecutors. The growing tendency to drop criminal charges. The tendency to minimize the official returns of crime. Roman penal law. Revision of judicial errors. Reparation to persons wrongly convicted. Provision of funds for this purpose. Reparation to persons wrongly prosecuted. Many criminal offenses should be tried as civil offenses. The object of a criminal trial.
2.
The crime and the criminal. The stages of a criminal trial. The evidence. Anthropological evidence. The utilization of hypnotism. Psychological and psychopathological evidence. The credibility of witnesses. Expert evidence. An advocate of the poor. The judge and his qualifications. Civil and criminal judges should be distinct functionaries. The student of law should study criminals. Training of police and prison officers. The status of the criminal judge. The authority of the judge.
3.
The jury. Origin of the jury. Advantages of the jury. Defects of the jury. The jury as a protection to liberty. The jury and criminal law. Juries untrained and irresponsible. Numbers fatal to wisdom. Defects of judges. Difference between the English and continental jury. Social evolution and the jury. The jury compared to the electorate.
How to utilize the jury. 4.
Existing prison systems a failure. Defects of existing penal systems. The abuse of short sentences. The growth of recidivism. Garofalo's scheme of punishments.
Strich von.
List scheme of punishments. The basis of a rational system of punishment. The indeterminate sentence. Flogging. The indefinite sentence for habitual offenders. Van Hamel's proposals as to sentences. The liberation of prisoners on an indefinite sentence. The supervision of punishment. Conditional release. Good conduct test in prisons. Police supervision. Indemnification of the victims of crime. The duty of the state towards the victims of crime. Defensive measures must be adapted to the different classes of criminals. Uniformity of punishment. The prison staff. Classification of prisoners. Prison labor. V. Asylums for criminal lunatics. The treatment of insane criminals. Crime and madness. Classification of asylums for criminal lunatics. The treatment of born criminals. The death penalty. Extension of the death penalty. Inadequacy of the death penalty. Imprisonment for life. Transportation. Labor settlements. Establishments for habitual criminals. Criminal heredity. Incorrigible offenders. Cumulative sentences. Uncorrected or incorrigible criminals. Cellular prisons. Solitary confinement. The progressive system of imprisonment. The evils of cellular imprisonment. The cell does not secure separation. Costliness of the cellular system. Labor under the cellular system. Open air work the best for prisoners. The treatment of habitual criminals. The treatment of occasional criminals. The treatment of young offenders. Futility of short sentences. Substitutes for short sentences. Compulsory work without imprisonment. Conditional sentences. Conditional sentences in Belgium. Conditional sentences in the United States. Objections to conditional sentences. When the conditional sentence is legitimate. The treatment of criminals of passion. Conclusion. Introduction. The positive school of criminal law. During the past 12 or 14 years, Italy has poured forth a stream of new ideas on the subject of crime and criminals. and only the short-sightedness of her enemies or the vanity of her flatterers can fail to recognize in this stream something more than the outcome of individual labors. A new departure in science is a simple phenomenon of nature, determined in its origin and progress, like all such phenomena, by conditions of time and place. Attention must be drawn to these conditions at the outset, for it is only by accurately defining them that the scientific conscience of the student of sociology is developed and confirmed. The experimental philosophy of the latter half of our century, combined with human biology and psychology, and with the natural study of human society, had already produced an intellectual atmosphere decidedly favorable to a practical inquiry into the criminal manifestations of individual and social life. To these general conditions must be added the plain and everyday contrast between the metaphysical perfection of criminal law and the progressive increase of crime, as well as the contrast between legal theories of crime and the study of the mental characteristics of a large number of criminals. From this point onwards, nothing could be more natural than the rise of a new school, whose object was to make an experimental study of social pathology in respect of its criminal symptoms, in order to bring theories of crime and punishment into harmony with everyday facts. This is the positive school of criminal law, whereof the fundamental purpose is to study the natural genesis of criminality in the criminal and in the physical and social conditions of his life, so as to apply the most effectual remedies to the various causes of crime. Thus we are not concerned merely with the construction of a theory of anthropology or psychology, or a system of criminal statistics, nor merely with the setting of abstract legal theories against other theories which are still more abstract. Our task is to show that the basis of every theory concerning the self-defense of the community against evildoers must be the observation of the individual and of society in their criminal activity. In one word, our task is to construct a criminal sociology. For, as it seems to me, all that general sociology can do is to furnish the more ordinary and universal inferences concerning the life of communities. And upon this canvas the several sciences of sociology are delineated by the specialized observation of each distinct order of social facts. In this manner we may construct a political sociology, an economic sociology, a legal sociology, by studying the special laws of normal or social activity amongst human beings, after previously studying the more general laws of individual and collective existence. And thus we may construct a criminal sociology, by studying, with such an aim and by such a method, the abnormal and antisocial actions of human beings, or, in other words, by studying crime and criminals. Neither the Romans, great exponents as they were of the civil law, nor the practical spirits of the Middle Ages, had been able to lay down a philosophic system of criminal law. It was Beccaria, influenced far more by sentiment than by scientific precision, who gave a great impetus to the doctrine of crimes and punishments by summarizing the ideas and sentiments of his age. One out of the various germs contained in his generous initiative there has been developed, to his well-deserved credit, the classical school of criminal law. 1 Desjardins. In the introduction to his Cahiers d'états généraux and 1789 et Law Legislation Criminelle, Paris, 1883, gives a good description of the state of public opinion in that age. He speaks also of the charges which were brought against the advocates of the new doctrines concerning crime, that they upset the moral and social order of things. Nowadays, charges against the experimental school are cited from these same advocates, for the revolutionary of yesterday is very often the conservative of today. This school had, and still has, a practical purpose, namely, to diminish all punishments, and to abolish a certain number, by a magnanimous reaction of humanity against the arbitrary harshness of medieval times. It had also, and still has, a method of its own, namely, to study crime from its first principles, as an abstract entity, dependent upon law. Here and there since the time of Beccaria another stream of theory has made itself manifest. Thus there is the correctional school, which Roeder brought into special prominence not many years ago, But though it flourished in Germany, less in Italy and France, and somewhat more in Spain, it had no long existence as an independent school, for it was only too easily confuted by the close sequence of inexorable facts. Moreover, it could do no more than oppose a few humanitarian arguments on the reformation of offenders to the traditional arguments of the theories of jurisprudence, of absolute and relative justice, of intimidation, utility, and the like. No doubt the principle that punishment ought to have a reforming effect upon the criminal survives as a rudimentary organ in nearly all the schools which concern themselves with crime. But this is only a secondary principle, and as it were the indirect object of punishment, and besides, the observations of anthropology, psychology, and criminal statistics have finally disposed of it, having established the fact that, under any system of punishment, with the most severe or the most indulgent methods, there are always certain types of criminals, representing a large number of individuals, in regard to whom amendment is simply impossible, or very transitory, on account of their organic and moral degeneration. Nor must we forget that, since the natural roots of crime spring not only from the individual organism, but also, in large measure, from its physical and social environment, correction of the individual is not sufficient to prevent relapse if we do not also, to the best of our ability, reform the social environment. The utility and the duty of reformation nonetheless survive, even for the positive school, whenever it is possible, and for certain classes of criminals. But, as a fundamental principle of a scientific theory, it has passed away. Hitherto, then, the classical school stands alone, with varying shades of opinion, but one and distinct as a method, and as a body of principles and consequences. And whilst it has achieved its aim in the most recent penal codes, with a great, and too frequently an excessive diminution of punishments, so in respect of theory, in Italy, Germany, and France it has crowned its work with a series of masterpieces, amongst which I will only mention Carrara's program of criminal law. As the author tells us in one of his later editions, from the a priori principle that crime is a fact dependent upon law, an infraction rather than an action, he deduced and that by the sheer force of an admirable logic a complete symmetrical scheme of legal and abstract consequences, wherein judges are compelled, whether they like it or not, to determine the position of every criminal who comes before them. But now the classical school, which sprang from the marvelous little work of Beccaria, has completed its historic cycle. It has yielded all it could, and writers of the present day, who still cling to it, can only recast the old material. The youngest of them, indeed, are condemned to a sort of Byzantine discussion of scholastic formulas, and to a sterile process of scientific rumination. And meantime, outside our universities and academies, criminality continues to grow, and the punishments hitherto inflicted, though they can neither protect nor indemnify the honest, succeed in corrupting and degrading evildoers. And whilst our treatises and codes, which are too often mere treatises cut up into segments, lose themselves in the fog of their legal abstractions, we feel more strongly, every day, in police courts and at assizes, the necessity for those biological and sociological studies of crime and criminals which, when logically directed, can throw light as nothing else can upon the administration of the penal law. Chapter 1. The Data of Criminal Anthropology. The experimental school of criminal sociology took its original title from its studies of anthropology. It is still commonly regarded as little more than a criminal anthropology school. And though this title no longer corresponds with the development of the school, which also takes into account and investigates the data of psychology, statistics, and sociology, it is nonetheless true that the most characteristic impetus of the new scientific movement was due to anthropological studies. This was conspicuously the case when Lombroso, giving a scientific form to sundry scattered and fragmentary observations upon criminals, added fresh life to them by a collection of inquiries which were not only original but also governed by a distinct idea, and established the new science of criminal anthropology. It is possible, of course, to discover a very early origin for criminal anthropology. As for general anthropology, for, as Pascal said, man has always been the most wonderful object of study to himself. For observations on physiognomy, in particular, we may go as far backwards as to Plato and his comparisons of the human face and character with those of the brutes, or even to Aristotle, who still earlier observed the physical and psychological correspondence between the passions of men and their facial expression. And after the medieval gropings in chiromancy, metoscopy, podomancy, and so forth, one comes to the 17th century studies in physiognomy by the Jesuit Nicetas, by Cortes, Cardenas, de la Chambre,
De la Porta,
and C., who were precursors of Gall, Spurzheim, and Lavater on one side, and, on the other, of the modern scientific study of the emotions, with their expression in face and gesture, conducted by Camper.